Colbert. I wanted to bring to your attention an interesting case that has been talked a little bit about in the press. It'll probably go by the wayside, but it deals with cooperatives and sponsors or holders of unsold shares and the ability to charge them sublet fees. Proprietary leases for New York cooperatives typically treat sponsors or holders of unsold shares a little bit differently for sublet fees. Sometimes it says that you can't charge them a sublet fee. Well, this recent case called Pastena versus 61 West 62nd Owners Corp., and I'll put a copy of this up on the screen. It said in dicta, which means that it wasn't necessary for the holding. It said that if factual issues were presented by plaintiff's contract of sale, and even if it was, that paragraph 38 of the proprietary lease, which purportedly exempts holders of unsold shares from certain expenses and fees assessed by the landlord, is void as a matter of law. Some commentators in the press have taken upon themselves to take that decision, which was back in February at the beginning of this year. The parties tried to re-argue. The court said no re-argument, so the case stands. It doesn't look like it's going to be appealed any further. So essentially, this first department, which is the appeals court in Manhattan, its position is that paragraph 38 in that particular case, which is very similar to most proprietary leases, prevents a sponsor from saying, hey, I'm not going to be responsible for sublet fees because the proprietary lease treats me different. That court essentially looked at the Business Corporation Law 501c, which essentially says shares of the same class have to be treated the same. So sponsors have to be treated the same as other cooperative shareholders, and they can't be treated differently. That 501c does have an exception to it, which deals with transfer fees and costs, but it doesn't mention sublet fees. So this court in Pastena looked back to a case back in 2003 in the first department, where the court, that same first department, said that that same paragraph, as it relates to sublet fees, is void. So you should keep an eye on this. Some co-ops will try to use it to their advantage with their sponsors or holders of unsold shares, and take the position that they can collect sublet fees from those holders of unsold share and or sponsors. Thanks.